When I purchased my home in the serene subdivision of Lakeside Meadows, I knew accessibility would be a key factor for my family. My husband, Marcus, is a disabled veteran who relies on a wheelchair. To ensure he could live independently and safely, we installed a wheelchair ramp leading from our driveway to the front door. We followed all the proper channels. We submitted our plans to the Homeowners Association, HOA, got the necessary approvals, and even had the ramp professionally built to meet safety and aesthetic standards. For months, everything was fine. Our neighbors were supportive, and Marcus was able to enjoy our home comfortably. Then everything changed. The ramp removal incident. One morning, Marcus came home from physical therapy to find a shocking sight. Our wheelchair ramp was gone, completely removed. No warning, no notice, just gone. Confused and alarmed, I immediately contacted the HOA management. Their response was dismissive and cold. They claimed the ramp violated the HOA's architectural guidelines, was unsightly, and that it needed to be removed to maintain neighborhood standards. I reminded them that we had obtained prior approval, provided all documentation, and that the ramp was essential for Marcus's mobility. They doubled down, saying the ramp was a hazard and not consistent with the community's look. Understanding my rights, I was stunned by their disregard, especially since the ramp was not only legal, but protected under the Americans with Disabilities Act, ADA, and the Fair Housing Act, FHA, both of which require reasonable accommodations for disabled residents. I contacted an attorney who specializes in disability rights, and together we prepared to challenge the HOA's unlawful actions. The message was clear. The HOA could not, under any circumstance, remove a legally approved accessibility ramp, especially without due process or alternative solutions. Filing the lawsuit. We filed a lawsuit against the HOA in federal court, citing violations of the ADA and FHA for failing to provide reasonable accommodation and for discriminating against Marcus based on his disability. The case garnered significant local attention. Neighbors expressed mixed feelings. Some sympathized, others echoed the HOA's desire for uniformity. But the law was unequivocal. The court battle during the trial, we presented evidence. The ramp plans, approval documents, photos of Marcus using the ramp, and expert testimony on the importance of accessibility. The HOA argued their position, claiming aesthetic concerns and property value protection. But the judge was firm. He emphasized that disability accommodations are not optional or secondary, and that the HOA's actions caused undue hardship and discrimination. In a landmark decision, the court ordered the HOA to reinstate the ramp immediately and to revise their policies to comply with federal disability laws. Aftermath and community change. The ruling was a victory not just for Marcus and me, but for all residents of Lakeside Meadows and beyond. The HOA board publicly apologized, pledged to educate themselves about disability rights, and worked with local disability advocacy groups to improve community access. I became a vocal advocate for disability rights, speaking at community centers and HOA meetings about the importance of inclusion and legal protections. Final thoughts. No one should have to fight for the right to live independently and with dignity, I say. When institutions like HOAs overstep and discriminate, the law must protect the vulnerable. I'm proud we stood up, not just for Marcus, but for everyone who deserves equal access.